SJC-10295, Commonwealth versus Matranga.
Good morning, Ms. Eisenberg.
Good morning, Madam Chief Justice. Good morning, Honorable Justices. Beth Eisenberg for the Committee for Public Counsel Services as the intervener appellant. Although this case has a somewhat complex background, the essential issue presented is very straightforward and it is important in our view, and that is, does the trial court's power under the indigency statute permit a post hoc judicial override of an enforceable contract?
Is there only one judge that's actively involved in challenging these bills?
No, that's an interesting question, and it actually is a point that I wanted to make to the court this morning, and I can address that directly if you'd like now. I think that lurking under the surface facts of this case, but alluded to in the court's July 31st, 2006 memorandum of decision in the impounded record appendix at page 31, is the court's view that there are serious compensation disparities between qualified examiners and defense experts. And I think that deserves a little bit of an airing this morning, because what the judge says is that qualified examiners are compensated on a half-day or full-day basis for their testimony. She says that in her memorandum of order. And she says it doesn't have to be that way, but the defense expert has chosen to bill at the hourly rate of $200 and has chosen to bill for his travel time. And all of our experts do that. We reimburse at an hourly rate, and we reimburse for travel. We have changed the reimbursement calculus for travel since the inception of this fiscal crisis. The committee has implemented a change in the hourly rate so that it is capped at the rate that a court-appointed attorney would get for the case, depending on which venue the case is tried in.
I mean, so if it's a Superior Court case, it would be
$60 an hour. Murder would be $100, and district court, I think, is $50 an hour, I believe.
That's for travel.
That's for travel. The committee has also recently voted to reduce by 5% the maximum amount allowable to be billed by expert vendors. This doesn't include interpreters and court stenographers and investigators, but for experts, the committee implemented in the wake of this crisis a 5% reduction.
Ms. Eisenberg, these fees and charges and expense reimbursements, travel and likewise, are made available to the legislature, correct? Made available to the legislature?
Well, the fees, I think there is a representation to the legislature of how the committee is allocating its resources, yes.
And to the governor?
I believe so, yes.
Now, the statute requires judicial oversight, is that right?
The statute requires judicial oversight under, we're talking about Chapter 261.
Yes.
Yes, for the granting or the allowing or denying of the initial request.
So what does that mean? I mean, I see a much broader problem here, and that is the problem, I'm not sure that, for sure that it's raised in this case, but that's the problem of the very high, and I'm not saying that they're not merited by the work that the people do, but the very high bills that the Superior Court judges are forced to approve for experts in this area.
Well, I think that what is raised in this case, and I agree with you that I don't think it's directly raised in this case, but I think that percolating under the surface of this case is what I would term as a kind of dislocation of legitimate concerns over the expense to the public of the 123A regime onto the respondent for defending his freedom against an indefinite commitment. I mean, if the judge in this case indicated in her written decision, she said, I appreciate that there are very few experts who are available in this field. And if you take that universe of experts and realize that there's only some percentage of those experts who are available to the defense, then the problem posed by the order in this case is that it chips away in a way that we think is not legitimate at the fees that are legitimately due the expert, and it's going to have the result of driving away experts from accepting cases from our agency, because these experts will not have any reason to rely on the integrity of the arrangement that's been entered into when the attorney has sought the funds and obtained the funds, and the expert has performed his service.
I have a major misunderstanding here. I thought you were suggesting in your brief that the role of the court is simply to determine whether or not the retaining of an expert was reasonable at public expense.
That's correct.
And that should be it. Then it's up to CPCS to decide how much to spend, how many hours is appropriate, what the right rate is. Is that right?
That's correct. I think the only thing I would say in response to that is that in Matranga, a post-services bill was submitted to the court. And there, I think, where a post-service bill is submitted to the court, it puts the judge not unreasonably in a slightly different position than the judge would be if presented with an application for funds before the services.
But there was a pretrial order of the court authorizing the retaining of an expert at public expense.
Exactly. And I think
so the bill shouldn't have been sent to the court. Is that your point?
Well, I think in Langlois, which is the underlying case that animates this illegitimate order in Matranga, all of the funds were allowed before trial. And so there was no controversy about additional funds to be sought. In Matranga, what happened was, after trial, the respondent's attorney submitted a bill to the court for, I think it was originally for $1,600, for services that had already been rendered, but the funds had been depleted, I think, in the course of trial.
You know, a few months ago when I was single justice, I got a case. It involves a slightly different problem in which the psychiatrist in one of these cases sought prior approval of a specific amount from the judge. Now, I take it that CPCS, or I was under the impression that CPCS trains the lawyers. CPCS has an ongoing relationship with the psychiatrists. It identifies them. It works with them. Doesn't it also tell the lawyers and the psychiatrists, submit the bills directly to us, don't submit them to the court? If that's what your legal position is, your premise is, that the court has, once the court approves the relationship, the financial payment is entirely between CPCS and the provider.
Correct.
So why are they sending bills? Why are lawyers and these psychiatrists sending bills to the court?
Well, but the court always approves of an amount.
Well, the court approves an amount. It may or may not be expended. What the court
No,
is
I understand that, but
yeah.
in other words, it isn't just the relationship. It isn't just that Mr. Matranga may have Dr. Plowd as an expert. It is Mr. Matranga or his attorney can retain the services of Dr. Plowd and can expend $2,500 on that engagement, right?
Yes.
So and I'm not.
Yes.
So
But that contradicts the position you take in your brief.
That was my first question to you, whether there's judicial oversight, because if there's judicial oversight and if the court approves them, and I agree with Justice Boxford, that's what I recall, then doesn't the fee have to be reasonable? And reasonable is whether the services are reasonably necessary and whether the amount charged is reasonable.
Well, I think the services have to be reasonably necessary, and with respect to the charges with respect to how much is charged, 211D endows CPCS with the authority to determine a reasonable rate of pay. Now, a judge can, under 261, can order the service to be provided at a lesser rate before that service is provided.
But that contradicts what every CPCS attorney does, which is to ask for an amount not to exceed, say, $5,000. You don't say, please authorize payment for this psychiatrist, and whatever it turns out to cost, your blessing.
Well, I think I think the way it works is that when an attorney files an affidavit with the motion, the attorney's affidavit is going to say, I'm looking for X amount of money for Dr. So-and-so, whose hourly
the motion
rate.
specifically says an amount up to
Yes.
$5,000, and then when it turns out that may not be enough, you make another request for X thousands dollars, and the court is essentially monitoring the public fisc to make sure that you don't give a blank check to a psychiatrist to throw in as many hours as he wishes to, and then ask the taxpayers to pay for it. I mean,
But
isn't
what
that
you-
part of what the judge is supposed to do?
Well, what you're supposed to be representing to the court is why it is $5,000. In other words, I'm retaining Dr. So-and-so, whose hourly rate is X,
Right.
and I anticipate it's going to take Y hours.
Yes.
Right.
Right. And so what the court can do in that situation is to say, I think that based on the curriculum vitae before me, or whatever the case may be, whatever the concerns are that the court may have, I think that those services can be rendered at a rate less than that. And
Okay.
if the attorneys aggrieve, they can take the appeal under 227D.
So you say the court can do that. Is that right?
I say that the court can make the initial determination of what the fee should be. What I say the court cannot do is to determine whether or not the bill that's submitted, once the fees have been allowed, then the bill that's submitted is the work of the committee.
But let me ask you this. If the just to take Justice Gantz's example, the request is for not to exceed $5,000.
Mm-hmm.
Case is tried. It actually cost $10,000. So after the case is tried, a motion and an affidavit comes in and says, well, it really took him, X more hours, and it's $5,000 more, so please approve this. Are you saying that the judge can't say at that point, wait a minute, we approved not to exceed $5,000, I'm not going to give you $5,000 more?
No, I'm not saying that. What I'm saying is that the court can look at the presentation after the services have been rendered, and I think at that point, if services have been rendered and funds have been depleted, that the expert and the attorney takes their chances in whether or not the court is going to approve those funds. But once the services have been performed and once the funds have been obtained, then I think the judge does not have the power to enter into the contract and to change the terms.
You mean to withhold certain money?
To withhold
all right.
monies
So
that
that's a
have-
much narrower.
that's-
That's a much narrower proposition than where we started, isn't it?
I don't, well, I certainly
I mean, I
hoped
agree,
and
that's
thought
what-
that was the argument of the brief, which was that there are two different issues here. One is whether or not the funds are going to be granted on a request, and that's certainly the power of the court, and whether or not the funds are going to be paid by CPCS. And that depends on all of these factors that are set out in CPCS's statute and in
Right.
CPCS's reimbursement policy.
But under our facts here, in this case, don't we have a situation where a judge was saying, in this case, I'm not approving your payment to the expert witness because in another case, I think that person was paid too much money?
Right. I mean, the problem that is presented by this case is that our position is that that's a completely illegitimate extrajudicial way
Okay.
to sanction a
That's
witness.
different. That goes to this particular individual's rights, correct? I mean, the funds should have been paid to, in this case, right? And there might have been, in order to show cause why the expert, shouldn't return certain funds from the other case, if that was the concern of the judge. But that's completely separate than what happens in a case where you've just got one case, one defendant, a single docket number. Here it's complicated because you've got two docket numbers.
Yes, it is complicated. It is.
But you go ahead.
Well, my question is, come back to the statute. The statute authorizes the court, it says, deny any request if it finds the standard is whether the document, service, or object is reasonably necessary to assure the applicant as effective a prosecution, defense, or appeal as he would have if he were financially able to pay. Now, doesn't that therefore mean that the judge has to look at the amount of time and the fee and the hourly rate and say, this is too much, all my other experts are $100 lower?
No, I think that the question of whether it's too much is for the committee in the
Well, then
end
what does
to
this
decide,
mean?
except if certainly the judge under the statute has the power to reduce the fee that the court is going to allow if the court believes that it can be provided at a lower rate and it doesn't impair the rights of the party.
Yeah.
But I think for a court to say this can be done at $100 an hour and this person is charging $200 an hour, and in my opinion that's too much, creates a conflict with an agency who's been specifically endowed by the legislature to set the fee rates.
I'm not quite seeing the distinction. Are you saying it's all right for the judge to reduce the fee if the judge has a basis for reducing the fee?
If the judge has a basis for reducing the fee, but the judge can't, of his or her own personal views, say that, in my opinion, this can be done at a lesser rate. I think there has to be a basis on the record.
But you are agreeing then that the judge may reduce the amount sought with a basis for doing so.
So long as it doesn't impair the rights of any parties.
What do you think, could a judge do this? Let's say before CPCS changed its travel allowance, but let's say that the estimate of the fee is going to be $5,000 and $1,000 of it is for travel time, paid at the rate of $250 an hour or $200 an hour. And the judge says, that's crazy. I mean, there's no reason you should be paid the same rate for travel as you are for other things. So I'm going to allow you some lesser amount. That's my basis.
Mm-hmm.
I don't agree with what travel should be on an equal basis as work, if you will. Could a judge do that?
The judge has the power to do that. I think the problem with that position is that it overlooks the fact that our experts are already providing services for us at discounted rates.
Ms. Eisenberg, I take it that the answer to that would be the following. Judge, this is an expert that I need because she happens to have expertise in the precise issue. The only way that I can get this expert, because the travel time is because this expert has to come from Barnstable. This expert gets paid on an hourly basis seeing patients in Barnstable.
Right.
Right? Judge says, don't care. There's an appellate route.
Yes.
Right?
Yes.
So as a general matter, you're quite correct. The judge can't just say, I don't think it's, I see other experts for $100.
Exactly.
Maybe it's because CPCS can't get those experts that day. Maybe they don't have a particular expertise.
Precisely.
But if a judge has a concern, the judge raises the concern, CPS explains why, judge rules, there's an appellate record. Correct? Now, in most cases, most judges are not going to get into that difficulty because CPCS is marshalling its very scarce resources and trying to do the best that it can. So most judges are not going to do that. But as I understand it, you're saying the judge could do that, but CPCS must have an opportunity to explain. And the one thing the judge can't do is post hoc take it from case A to pay case B, and post hoc with no foundation just say, I don't think I should be paying, the CPS should be spending this kind of money.
And that is the four squares of this case. I mean, the case is unusual. It does raise, as this court said this morning, and as I agree, it raises resonances about,
it's not quite the same, but in applications there are circumstances in which statutes provide for attorney's fees.
Mm-hmm.
By and large, if there's not an opposition to the hourly rate or to the amount of time expended, by and large the court may look at it, but if there hasn't been an opposition, the court will by and large allow the attorney's fees. Right?
Yes, I don't know, opposition by
But in this
whom?
case, these cases, there is no opposition.
There's no opposition. I'm not sure.
in these cases. The
I'm
DA
not
can't.
sure that
DA
the-
can't do
it
anything
gives-
in
exactly,
opposition.
yeah.
So there
No, what
is
I'm
no
saying
opposition.
is, so,
Right.
so here what you have is a judge sua sponte saying, I think this is unreasonable, when there appears not to have been a claim by anybody that it's unreasonable.
Correct, that's right.
But
There
there
couldn't
can't
be.
be.
There
There
couldn't
can't
be.
be, because there's nobody to oppose it, just like here, the Commonwealth didn't file an opposition.
Right, the
Nobody can oppose it. There's just one side.
That's true. That's true. There was no claim here, and there can't be a claim
Right.
here. There's no standing in the government to
Right,
say.
so there never will be any opposition.
However, I think what's important to remember is that it would render the 211D Section 9, subsection I, without any real power and effect if a judge could, in every case, decide to override reimbursement rates and reimbursement protocols and certification requirements.
That's my point. I mean, I understood precisely that nobody can come in and oppose, but what I'm saying is, given that there's a statutory thing, there has to be some, for a judge to raise it sua sponte, there has to be some...
There was no controversy before the court.
Well,
That is
even if
right.
there's not a controversy, there has to be some, as it were, compelling reason, something jumping out. And what appeared to be jumping out to this judge was two things. One is you were overpaid in another case. Now, it seems to me that there are appropriate administrative ways that one can look at that, because the judge is sitting as only one judge of hundreds of judges who are making these determinations. And second, you know, that it may be that this expert is being charged more. And second, what this judge was doing was, in fact, mixing up two cases.
I think the judge was interpolating case A into case B, and I think it was intentional. I think she felt that there had been an overpayment, it hadn't been satisfied, and that the order was directed at the witness through the instrumentality of CPCS, and that is why we intervened.
Well, let me ask you, let's take an example which I know is not this case. Let's assume you have an SDP defense psychologist who's supposed to testify on Friday and doesn't show. And the reason he says it was a beautiful day and I wasn't going to miss playing golf on that day. And the jury, which otherwise would have had the case on Friday, now has to return on Monday. He comes on Monday and he testifies. Are you saying the judge is not able to impose any appropriate sanctions against that psychiatrist for failing to show up as promised on a particular day?
We've never said that.
Okay, so
We've
what's the
never
judge supposed to
taken-
do then?
I think the judge should hold a contempt hearing.
Well, it's not contempt.
Well,
There's no
it may
order
be
of the
very...
court that he's supposed to appear.
If there is an order of the court, if there's no order of the court, it still interferes with and delays significantly the business of the court, where certainly hearing can be held and she can sanction that individual after.
Okay, and isn't
after
that
the
what
hearing can be
basically, I
held.
mean, I gather that he was invited to prepare an affidavit in this case, and he
Right.
chose not to. He chose not to do an affidavit,
Well,
and she sanctioned him.
but
So-
well, no, she sanctioned him and then she invited him to file an affidavit, but I'm not his attorney, but it seems to me he had no incentive to file an affidavit at that point because, as we've represented in the brief, he'd already been paid in full.
Right, but he's still continuing now as he appears in court again. He
Yeah.
appears in court every week. The court is powerless to say, you owe me $120, I'm going to take it out of the next payment? That's what she did, basically.
No, I think what she had the power to do and what the chief counsel told her she had the power to do, both in his letter in August of 2006 and before her in a hearing, was not to use CPCS as the arrow in the target, but to use whatever repertoire of inherent power she had as a judge to express her displeasure directly to the witness and to sanction the witness if so warranted. What we took issue with was
In other words,
the
you're
order to
suggesting that
us.
she could have fined the witness.
She could have fined the witness.
And then she could have entered an order, and then if the witness didn't pay, and which would go into...
our position has always been what's dangerous is to use the agency as the instrumentality to express displeasure to a witness, not that there may not be circumstances.
It's not expressing displeasure. She already has expressed displeasure. It's to collect upon an unpaid sanction, essentially.
Well,
then she issues an order, and
I mean, it certainly was complicated by the fact that by the time the order came out, the bill had been paid in full, and there wasn't an order, at least at that point, to CPCS to recoup that
Right, it's not, no one
overpayment.
says CPCS, at least I'm not saying CPCS was at fault, but you have Dr. Plowd, who was supposed to pay $120, and he didn't. And he's appearing in court every month, and he's being paid by the court, and the court can't say, you owe us $120, instead of paying you $10,000, we're going to pay you $9,880 and take our $120 back that way?
Yes, that's our position. The court cannot do that. If there are no other questions, I'll rest on the brief.
thank you, Ms. Eisner.
Thank you very much.
SJC-10297, Board of Registration in Medicine versus Hallmark Health Corporation.